This conference will now be recorded.
So I'd like to thank everybody who made time in the middle of the week to join me today for our webinar called Top 5 Planning Tips Every Parent of a 17-year-old Special Needs Child Needs to Know. I'm going to ask everybody to mute their microphone. Somebody has joined us and they need to mute their microphone. Okay. So today we're going to discuss the importance and how we go about creating a comprehensive plan for our adult children's future. You know, as parents, we probably tend to think of ourselves as being superhuman, supermortal, and thinking that we're always going to be here in a physical form to take care of our children. The reality, when we think about it, is that's not going to be the case. So that's why we have to slow down, stop, and think through the issues that we're going to be talking about today, which is planning for that time when, either due to our own incapacity, perhaps an accident, unforeseen, a disability, and eventually a death, we're not going to be here to supervise and guide our children. I think it's important for all of us to remember that every person is a multi-dimensional human being. And that means that there are many different aspects that we have to think about and coordinate as we create a plan. Now, while I'm the elder law attorney and I can guide you through the problems to create legal solutions, there's also going to be financial issues, social issues, as well as medical issues that need to be part of the plan as well. And that's why I find that what helps people achieve their goals is to have that team of professionals that they can work with so that the entire picture becomes balanced. It is coordinated, and it's really the best way to support the overall family so that they can support the child with special needs. So today we're going to go through together the top 5 questions that most parents ask, and if they're not, then that's why you're attending today's webinar, so that you know the questions to ask and what the possible solutions are. The first question is, who is going to be able to make medical and financial decisions for your child when he or she turns 18? In Florida, 18 is that magic age where they're no longer considered children under the law, and they're considered an adult who has all the same legal rights that you and I have. The second question we're going to walk through together is, what is the difference between a guardianship proceeding and a guardian advocate proceeding? My hope is that this will spur you on to starting to think, if your child is 17 or coming close to 18, about which type of proceeding is going to be best for your child. The third question is, how can you leave an inheritance for your child without it negatively impacting their entitlement to government benefits? And this is very important, and we have some wonderful solutions that we're going to share today. The fourth question is, what are those government benefit programs that might be available when your child becomes a legal adult? And how do you prepare to qualify your child for those entitlements? And last but certainly not least, we're going to talk about how to maintain government benefit eligibility at the same time maintaining your child's independence and dignity. So our first question about who can make medical and financial decisions for your child when they're an adult is a very personal decision. And what I mean by that is it really depends on your child's capacity to understand. So in law, in order for an attorney to prepare legal documents such as a durable power of attorney for an adult, there's a very high standard, a high level of capacity of understanding that is required in order for it to be possible for us to prepare that document for an adult child who has either a developmental disability or perhaps a disability that resulted from an accident or an illness. But the highest level is needed for the durable power of attorney. So we're looking, for example, at what is the child's level of awareness? Can they tell us the month, the day of the week, the date, the year? Do they have a comprehensive awareness of who their family members are? If they have assets or income, are they aware of what those are? So you can see by those questions what we need to evaluate. It's not simply a question of can the adult child hold a pen in their hand, and if mom or dad says we want you to sign this, can they sign the document? It actually goes much deeper than that. Now, for healthcare decision making, sometimes the child has the necessary level of capacity where we can create for them a designation of healthcare surrogate, which is a document that allows an adult to decide who they would like to make healthcare decisions for them if they need assistance or if they become unable to communicate. So it is a lower level, a lower threshold of comprehension and understanding that's required. So this is going to be very unique and dependent on each adult child's capacity. Sometimes it may be that we can't do either of these documents, or it might be that we can do the designation of healthcare surrogate, but not the durable power of attorney. So if we're not able to create either legal document for the adult child, we want to explore what is the next planning option so that somebody in the family can be entrusted and responsible for making medical and financial decisions. So here you see the chart that I've created, and we're going to walk through and compare the guardianship to the guardian advocate proceeding. Both are court proceedings. So with the guardianship, the purpose is to appoint.
We're not seeing your chart.
Oh, I apologize. Bear with me.
I don't know if you have a presentation with slides, but we're not seeing it.
I apologize. Thank you for letting me know.
No worries.
Okay, so whoever is speaking, can you let me know if you're able to see the chart now?
Yes, it's Lisa. We can see it, but we're not seeing it full screen. You have your notes on the side there. There you go. You're good now.
All right. Thank you so much. I appreciate that.
You're welcome.
So start from the beginning. As you can see, we touched on why it's important to create a comprehensive plan for soon-to-be adult children that have special needs or disability. We need to recognize that we are human, and at some point in time, we ourselves may become ill or pass away. So we want to start thinking about these things now, and certainly to have a comprehensive plan that's going to include other professionals. So there's a team of people all using their knowledge and their different disciplines to help you, your family, and your child. So now we're going to walk through the chart that compares a guardianship to a guardian advocate proceeding. Now, while both are intended to allow a court-appointed individual to make medical and financial decisions, you'll see that under the column for guardian advocate, that the advocate is really intended to provide support and guidance to the adult child, whereas the guardian actually makes all the decisions. So the legislative intention behind our guardian advocate law in Florida is to recognize that individuals born with developmental disabilities have different levels of abilities and capabilities. And so we want to empower them to be involved to the extent they can be. And where they need the support or the guidance, that is where the guardian advocate would step in. So an example that we see fairly frequently is that an adult child has turned the age of majority, and they take their child to the dentist for an annual checkup. And after the x-rays are done and the actual assessment of the dental condition is done, the dentist then explains to the adult child and the parent what they found. So let's presume, for example, there's either a cavity, maybe a root canal is needed, or some sort of medical procedure. If the adult child can't grasp, can't comprehend what the doctor is saying and what is the recommended course of action, the dentist is likely to turn to the parent and say, I'm sorry, we can't proceed. You can no longer give medical consent because your child is now an adult. And that's the most frequent type of call that I receive here in my office. So at that point, we either need a court-appointed guardian or a court-appointed guardian advocate who will then have official paperwork signed by the judge and is able to then show this to the dentist as well as the treating physician, any specialist, and then be able to be involved in the decision-making process, including having access to confidential information that is considered protected under the federal HIPAA law. As you can also see from the third column of the chart, Florida has very specifically identified certain disabilities that are considered developmental disabilities. And as you can see, this is not a very long list. So sometimes it is possible that somebody is born with a very rare genetic disease, but it's not on the list. In that case, we are not allowed to use the guardian advocate proceeding, and we need to explore whether the guardianship would properly meet the needs of the adult. Another difference between the two proceedings once you get to court is that with a guardianship, since we're actually removing legal rights from the individual, the court is going to send out what is called a medical examining committee. And this is made up of 3 professionals from different disciplines. So we might have a medical doctor, a social worker, a nurse, or another type of medical professional. And they are all going to go meet with the adult at different times and speak with them, communicate, talk with the parents or a family member who is with the adult. And they write up a report that is given to the judge and to the attorney that tells us, do they feel a guardianship is necessary? And if so, what legal rights should the person keep? And what legal rights should be given to the guardian to exercise for them? And you can see in that middle column under guardianship, every one of us automatically have the right to decide if we want to marry, to vote and who we're going to vote for, to travel, to have a driver's license, to sue, meaning if somebody injured us and we're going to sue to get benefits under their insurance policy, or to defend lawsuits. We all have the right to sign a contract, to manage our assets, or to make a gift of our assets. We have the right to decide where we're going to live. What state is it going to be? Or with whom is it going to be? We all have the right to obtain a job, to apply for government benefits, as well as to make our own medical decisions and our own mental health decisions. So in a guardianship, each one of these rights is being evaluated. And that is what the judge is ultimately determining is, does this person need the guidance and support of a guardian to make decisions for them? So the examining committee must give an opinion. Are there any rights that the person can keep and exercise safely? And what rights do they need the guardian to manage for them? You'll see in comparison in the third column of the chart, in the guardian advocate proceeding, we are not removing any legal rights. So if you would like to help your child understand the importance of voting in our country and help them to understand the different candidates and what each candidate stands for, and assist them in participating in the voting process, they will actually be able to do that. That is not taken away from them. So to help you navigate to making a decision, some of the things I think are important have to do with the right to contract. And as we talk today, I'm going to do my best to give you examples and share with you some situations of clients I've represented over the years. If, for example, there are assets in your child's name, you may then want to evaluate, is your child susceptible to possibly being unduly influenced by people or friends that they may meet? Could they be placed in a situation where they are taken to a car dealership and asked to sign a contract or to co-sign for a friend that would make the child financially guarantee this debt? So that's, I think, something important for you to consider. Because if the right to contract is retained in a guardian advocate proceeding, it may be more difficult when you realize this has occurred to undo it. Whereas in a guardianship, if the right to contract has been removed, it is much easier to undo this financial situation without there being any financial liability. And the reason for that is because there will be orders signed by the judge in the court file that say the right to contract has been removed. And so once we're able to show that to the dealership, they should just completely undo the transaction. So those are things you want to think about. Is your child going out into the community, not always accompanied by you? Are they with friends? Are they in any kind of social setting where they might be taken advantage of, and they may not recognize or be able to distinguish the difference between somebody that is a true friend and somebody who is a stranger attempting to befriend them and gain their trust and confidence. So that, I hope, will help you as you determine what is best for you.
Stephanie, this is Lisa. I put something in the chat box. I don't know if you can address it.
I'm going to ask, actually, if we can wait till the end, and I'll be happy to look at all the questions in the chat box.
Thank you.
Thank you. So now we're going to talk about how can you leave an inheritance for your child who has special needs. So first and foremost, please don't disinherit them. That is a very old-fashioned approach to this situation. And I'm glad that you're here with me today, because then I know that you won't do that. The danger of disinheriting and actually giving the assets to other adult children and telling them in private that you expect them to share it or use it to take care of their sibling is that there are unforeseen, unexpected, unintentional future events that can occur that will derail that plan. For example, if the adult child that you're leaving the assets to with the intention that they take care of their sibling who has special needs gets divorced, those monies that were inherited may end up being divided in the divorce proceeding. Or if that adult child receiving the inheritance has a business and the business is failing and they've received advice to apply for a bankruptcy, they're going to have to report that inheritance in the bankruptcy court, and it may very well be used to pay off their creditors. So while we would never expect or plan that a divorce or a bankruptcy is going to happen, on the chance that it does, that inheritance is not going to be there to do what you intended it to do. So we want to talk a little bit about using this tool that we call a special needs trust, because this is really the best and the safest way to plan for the inheritance, know that the money is going to be there, and simultaneously know that you are preserving your child's entitlement to government benefits. So the first thing I'd like you to be thinking about is, who are you going to give the responsibility to handle the special needs trust after you've passed away? We call that person a trustee. They have a special duty to manage and properly invest the assets to make them last as long as possible. You also want to be thinking about naming a successor trustee. Think of this person as part of your backup plan. We want to have a plan that can take into account anything we don't have the crystal ball to know may happen. So if the first trustee you name gets sick, or for whatever reason cannot take on the responsibility when the time comes, at least you have that successor trustee to step into the shoes. And there's no limit as to how many successor trustees you can name. But what I want you to do is I want you to first have a conversation with the people you're thinking of asking to be the trustee and the successor trustee. I don't want this to come as a surprise and they find out after you've passed on. It's important to have the conversation now and be certain that they are willing to take on the responsibility, that they understand what is being asked of them, and give the two of you an opportunity to talk through and for you to share with them your concerns as well as the preferences you have and what's important to you about how to spend the money for your child. What makes this special needs trust work, and when I say work, what I really mean is that allows your child to keep their Medicaid and their SSI benefits, is that the trustee will never give the money to the adult child. They will never put it into their hands. The trustee is responsible for giving the money to the vendor that is providing your child with either a service or a product. And by doing it in this way, the money never comes into the hands of your child, so they stay within both the resource limit as well as the income limit for the program that provides them with the benefits. This is the key. Now, another thing that is very important about planning in advance, meaning this special needs trust can either be created in your last will and testament, or if you have a revocable trust, it can be created in there, or we can create its own standalone special needs trust document. Because these are your assets and you no longer have a legal duty to support your child when they turn 18, there is no payback provision that has to be included in the document. What that means is I do not have to write language that says when your child passes, any money left goes to repay Medicaid. That is not required because these assets that are funding the special needs trust were yours. They were never your child's assets. And if you walk away with nothing else but this today, that's what I want you to understand. By doing this now while you're alive, there is no payback provision. If you put this aside and you get caught up in day-to-day things and say, I'll do it tomorrow, and tomorrow never happens. Once your child inherits the money at your death, what we can do is a different kind of special needs trust, but it is required at that point in time to have the payback provision to Medicaid. So I know nobody who's attending today is going to let that slip by, right? Everybody is now going to be getting the special needs trust in place. So what you're able to do is decide who will be the alternate beneficiary when your special needs child passes away that's going to receive whatever's left in the special needs trust. You can leave it to family members, you can leave it to a charity, you can leave it to a foundation. That choice is solely up to you. There is no law to dictate who you have to name. So please start to think about these three important things, naming the successor trustee, naming the primary trustee, not having the payback provision, and designating an alternate beneficiary. Now, before we start to talk about some of the different government benefit programs that are going to be available to your children when they turn 18, I want to talk just a little bit more about what kind of assets can actually go into the special needs trust. So we can include, for example, your home, any kind of real estate, even if it is a rental property. We can include bank accounts. We can include investments. When it comes to things such as retirement type of accounts, those could be IRAs. They could be 401k accounts that you saved for over the years. There are some unique rules with those retirement accounts. So when we meet, we need to talk through those issues as to how is best to designate the special needs trust as the beneficiary of a retirement account. For the other things we talked about, like bank accounts, checking, savings, money market, certificates of deposit, perhaps if you have an investment account, we can help you when you get the beneficiary designation form, fill it out and designate the full proper name of the special needs trust as the beneficiary. And what that does is it ensures that the assets on the day you pass are going directly into the special needs trust. They're not first passing through to your child and then to the special needs trust. So this is a multiple step process, but it is all doable. People do this every day, and so can you. We just have to plan in advance. So now we're going to turn to different government benefit programs that are available when your child turns 18. And as you can see from the chart on the screen, we're going to talk about 3 of the main. These are not the only ones, but these tend to be the main programs. The first one we're going to discuss is called Supplemental Security Income, and the abbreviation that Social Security uses is SSI. Now, this provides the child with a monthly subsidy. I used to say a check, but Social Security really doesn't send checks anymore. They do electronic deposits right into the bank account that you've requested. There are, however, financial requirements in order for your child to qualify. There is an income requirement and there is an asset requirement. Now, for some parents, they try to apply for their child for this program before the child reached the age of 18, and they may have been denied and not thoroughly understood why the child was ineligible. So it's important to understand that when our children are under age 18, the law expects us as parents to provide certain support, food, clothing, and shelter. And for that reason, if we apply for SSI for our child before age 18, the government is allowed to ask us what are our own assets and our own income. And so if our income and assets exceed those levels, that is going to be the reason why Social Security is going to deny the application. But on the day after our children turn 18 and they are now legal adults, none of the government agencies are permitted to ask what the parents own. So the application is evaluated looking solely at the adult child. So as long as the adult child has no more than $2,000 of resources in their name, they're going to meet the asset requirement. And as long as income, meaning they might have a part-time job and they're earning wages, as long as the gross wages for the month are within the income limit that Social Security sets each year, they will meet that requirement as well. Now, for as long as I have been practicing, Social Security has always had the same standard for the asset limit, which is $2,000. But each year in December, they increase the income standard. And that is because of the cost of living adjustment. So if your child right now is 17 and they're not going to turn 18 until the year 2021, it's best to wait to know what that income standard is going to be, especially if they're in any kind of work-study program and it's intended that they're going to have a part-time job. The other requirements that Social Security is going to look at is the age, whether the individual applying is blind, and if they're not meeting the age standard or the blindness standard, they're then going to be looking at what the disability is. So they may ask for you to sign an informed consent form to get access to medical records for your child in order to understand what the diagnosis is and to see if it meets within their medical book the standard for disability. And disability is basically defined as having an illness, a disease, or diagnosis that prevents somebody from being substantially gainfully employed. Now, here in Florida, we have an additional benefit that's tied to the SSI program. So when your child gets approved for SSI, they are automatically going to be approved for basic Florida Medicaid assistance without you having to go to the Department of Children and Families and apply through a separate application process for Medicaid. And that's unique to Florida. There are a few other states that do this, but not every state in the country does. So it is important that at all times your child maintains at least $1 of SSI a month in order to keep the Medicaid. If they were to lose SSI 1 month, they will also lose the related Medicaid benefits. So think of them as working in partnership with one another. The second benefit program we're now going to discuss is sometimes called Disabled Adult Child Benefits, and the acronym Social Security uses is DAC. Now, this also is a monthly subsidy. However, it is not paid until a parent retires or a parent passes away, unlike the SSI, which your child can apply for as soon as they turn 18. What is unique about the DAC program is that there really is no financial requirement. And as a result, the amount that is paid in most situations is far greater than the SSI payment because it is tied into the parent's work history, the tax credits that the parent has in the system. However, there are other requirements that have to be met. For example, we have to be able to prove that the adult child's disability occurred before age 22. So what I encourage everybody to do is to make sure that you've got the medical records or the medical tests that show the diagnosis. And since we are living in a technological society, please make sure that you have this scanned, that you've given it to relatives that you might end up naming as the trustee of the special needs trust, or a relative that maybe is going to be the successor guardian or the successor guardian advocate for the child. It's important that these records not disappear and not be destroyed. The second requirement is that the child cannot be married and the child cannot have worked. So the intention behind the DAC program is to really provide more supplemental financial assistance for an adult child with a severe disability or a severe diagnosis. Although the amount of this benefit is going to be far greater than SSI, and it may end up exceeding the income and the asset limit for Medicaid, there is written into the federal law that there will be no loss of Medicaid assistance. Now, this does not mean that a mistake does not happen in the government agencies. And I have had situations that we needed to write a letter to Medicaid explaining that the benefit shifted from being SSI when the parent was alive to being DAC when the parent retired or passed away. And once we were able to provide that explanation, they reinstated the Medicaid. But I want you to know that this is federal law, that there will be no loss of Medicaid. The next program that we're going to discuss was years ago part of the program that was handled by the Department of Children and Families, but eventually our governor created a new agency, which is called the Agency for Persons with Disabilities, and the Medicaid Developmental Disability Waiver Program was then brought over to APD. So this is a program specifically designed for children born with developmental disabilities as opposed to a child that was born healthy but later on in life, either due to an accident or an illness, became disabled. So that is the first requirement in order to apply. There are different types of Medicaid services that are available through this program as compared to if you were to apply for a Medicaid program through DCF. And when an adult child is assessed and their application is approved, the next step or the next stage is that they are given a certain amount of funding, and a support coordinator is assigned to that adult child to determine what is the best way to allocate and spend that money, that budget, among various types of services that the adult child will need. So sometimes people may apply for their child for SSI and find that the basic Florida Medicaid benefits are enough, or they may not be enough, so you may then want to submit an application to APD. Now, unfortunately, in Florida, the APD program has not been well funded over the years, and they tend in metropolitan counties like Palm Beach, Broward, and Miami-Dade, they tend to have a waiting list. So there is no harm in getting your child's name on the waiting list, and I do recommend it simply because if unexpectedly the parent were to suddenly pass away and perhaps there is no other parent alive, there is a way to very quickly, through what's called a crisis tool, get that adult child's name off the waiting list and be able to immediately receive services through this waiver program. So I do recommend that you apply, but be aware that it is likely you can get a letter in response acknowledging the application, but saying that the child's name has been placed on the waiting list. So next, we're going to talk about another way to help your child maintain their government benefit eligibility and also their dignity. So back in late 2014, a bill was proposed in Congress called the ABLE Act, which became law in 2015. And what ABLE stands for is Achieving a Better Life Experience. And thanks to parents like those who are on today's webinar, they got the support of their legislators to recognize that there are some adults with special needs that are able to work, or perhaps family members would like to give them a gift, and to have that money available, whether it's for housing purposes or to improve the quality of their life in some way. But they didn't want those monies to cause them to lose the SSI or lose the Medicaid benefits. So an ABLE account is a way that wages from employment or gifts from family members can be placed in an ABLE account and enable the adult child to have that experience of independence and dignity, and really to develop their maturity, to be involved in deciding how will that money be spent. So here in Florida, our ABLE account is handled by the same organization that handles the Florida prepaid college tuition plan. And because they had that prior experience, they're able to bring that and their organizational skills to this program. Now, there are certain requirements so that the account value is not counted against the adult child. And some of these rules are tied into Internal Revenue Service tax rules. So for example, there is a limit to how much can be contributed annually, and that's not per relative. That is total for the calendar year between January 1st and December 31st. So that limit is set at $15,000. So it is very important, if you're going to share this information with family members, that they understand everybody needs to talk to one another so they're not contributing too much within the 12-month period. The second requirement is when opening the account, you have to be able to prove that the adult child had the qualifying disability prior to age 26. Now, if your child is receiving supplemental security income, then the maximum amount that can be in that account is the sum of $100,000. Okay, that's really important to keep in mind, is to watch the statements in case they're growing, either because more monies are being added, or it might be a combination of more monies being added and gifts being made to the child. Now, more recently, in the last year to a year and a half, there was a change in Florida law. So now, when the adult child passes away, Florida Medicaid cannot file a lien against any monies that are remaining in that adult child's ABLE account. So this is a great win-win for our special needs families in Florida. Now, I've given you just a few examples of what are called qualified disability expenses, but these are probably the most important ones and the ones that families most frequently use for spending the money in the ABLE account. And what's important to understand is that if you stay within these guidelines and the money is spent on qualified disability expenses, then there is no loss of SSI or Medicaid benefits. So, for example, housing is usually a big ticket item, and housing could be rent for a supported living environment. It could be a mortgage if the parent left a home to the child, but there's an outstanding mortgage to be paid. Educational expenses, that might mean a private tutor or private tuition. Those are also permissible qualified disability expenses. Transportation, let's say your child needs to get to doctor appointments or get to school or get to work. That's permitted. Employment training, assistive technology. You know, every year we hear of more and more technological developments that are being created that help children with varying disabilities and illnesses. And unfortunately, many of those are not covered by Medicaid assistance. So assistive technology is one of those qualified disability expenses. And while it's never pleasant for us as parents to think about the fact that at some point in time our children are going to pass away, I do recommend that we explore and even take the time to purchase and prepay for funeral expenses. It's hard enough when a death occurs to go through the stages of grieving without also having to deal with paying for those funeral expenses. So funeral expenses is considered one of the qualified disability expenses. So I know that we tried to impart a lot of information today in the span of an hour, and I want to encourage everybody to visit my website. There's a lot more information that I have for families and individuals at www.fl-elderlaw.com. On the website, you can also download a gift certificate and use that for a consultation. Our client liaisons are happy to work with you and set up the consult and tell you what you will need to prepare. I also want to encourage everybody to join me on this Friday, May 29th at 12:30 p.m. It's our last webinar to celebrate National Elder Law Month, and it's called Don't Try This at Home, the Dangers and Pitfalls of Applying for Medicaid and VA Benefits Yourself. Now I'm going to open the chat box and address the questions that have been written there. So the first question says, When an individual has a mental health illness that impacts their ability to manage their world, would these options be appropriate? And how is their disability assessed to qualify? So, Lisa, I'm going to ask you to unmute your microphone, and I want to make sure I'm understanding your question correctly. Are you asking about the options between guardianship and guardian advocate?
Yes.
Okay, so thank you. I appreciate you qualifying. And it's a great question, and I'm going to tell you why. A few years ago, I had a first-time experience in my law practice where I represented a client whose adult child actually had a dual diagnosis. And her dual diagnosis was that she had autism, but she also had a mental health diagnosis. And when we saw the reports come in, and we had the hearing in front of the magistrate, while we had filed requesting that the parent be appointed guardian advocate based on the autism diagnosis, the magistrate denied the request because he felt that the mental health diagnosis was stronger, that it really overshadowed the autism. And we were directed to then file for a guardianship for the adult child. So again, we don't always have black and white rules of thumb to go by. A lot of times there's gray areas, and that's why each adult child's situation, their abilities, their diagnosis has to be evaluated on its own merits in order to determine, is the guardian advocate proceeding appropriate, or do we have a dual diagnosis and there is a good likelihood that the court would deny the request to appoint a guardian advocate, and so we should just go the guardianship route. Does that help to answer your question?
Yes. The only thing I guess I'm curious, because I was going through this presentation, I saw that the focus was really much more on developmental disability population. So that's why I guess my question had to do with, if there is a mental illness involved in the situation, does all of this apply? And it's interesting that you noted that a diagnosis of a mental illness overrode the autism with regards to benefits or programs.
Well, not so much benefits or programs, but in that client's situation, her daughter had been Baker Acted several times. Mm-hmm. And for those of you who are not familiar with the term of art, Baker Act, it is an involuntary proceeding where somebody who is either a danger to themselves or a danger to somebody else, where they're going to cause imminent harm, they are taken to the nearest receiving psychiatric hospital for 72-hour observation and treatment. And so it was clear that her being Baker Acted had nothing to do with the autism, it was the mental health illness. And there was also a drug addiction her daughter had. And so in that specific circumstance, the magistrate and the judge agreed that the guardian advocate proceeding would not be appropriate.
Okay. So it sounds to me it's very individualized.
It is, exactly. Yet the other things that we talked about today, such as the use of a special needs trust in order to manage an inheritance for an adult child, would absolutely be a great planning tool for somebody with a mental health diagnosis.
So that's not based on diagnosis at all?
No, you have, whether you, the parent, are creating a special needs trust to hold your child's inheritance, or if the adult child has already received the inheritance and now a special needs trust has to be created, one of the first requirements is that the person has to have a disability. You can't be healthy.
Okay, but it's not a developmental disability. I guess I should have reframed that. Right,
yes.
Okay.
It does not have to be a developmental disability. It can be a disability that occurred due to an accident or an illness. For example, I have worked with families where children are believed they were healthy, and they believe that a childhood vaccine, caused a disability. And so we've used special needs trust to help those children as well. So now I'm going to move on to the next question in the chat box. If you created a special needs trust early in your child's life and then believe that your adult child would not need it due to change in abilities, how do you dissolve the trust? Wow, it's another great question. We could actually spend a webinar just talking about how a special needs trust gets administered and why it's so important to be very creative in the language that the attorney uses to write the special needs trust agreement. So the approach that I like to take when writing a special needs trust agreement is to think about this exact scenario. So I like to include language that says that at least on an annual basis, the trustee should use trust funds to have an assessment or a reevaluation done of the trust beneficiary. And if the trustee, with the guidance and the advice of professionals, that could be medical professionals, legal professionals, financial professionals, decide that there is no longer a need for the special needs trust. And that's going to take a lot. That's going to take a medical evaluation. We need to confirm that that adult is either declining or is canceling their government assistance through the Social Security agency and the Medicaid agency. Then the trust actually continues, but rather than the trustee having to give the money to the vendor, they will now be able to distribute the money directly into the hands of the trust beneficiary. So that is one of the approaches that I have taken. The reason I would not want to dissolve or terminate the trust is because, again, we don't have the crystal ball, and what if circumstances were to change again. So I would rather we leave the special needs trust in place, but now we change how we're administering the special needs trust assets. Another question I see in the chat box asks, is there a minimum amount to establish a special needs trust? And the answer is no. There is no magic number. It's really personal and unique to every individual and every family. However, the draft special needs trust may not be financially feasible in every situation. So we also want to explore an option called a pool trust, which is another type of special needs trust allowed under the federal law. And how it differs is instead of an individual serving as the trustee, it is actually a charity that serves as the trustee, and multiple individuals are allowed to participate in the pool trust. So they can pool their resources, their inheritances, their personal injury settlements into a pool trust account for them. It is a lesser expense to create as well as generally to administer because the cost is spread among all the participants. So sometimes that may be the better planning option rather than drafting a special needs trust just for that one individual. The last question that I see in the chat box is asking, when we were talking about the ABLE account needing to have a maximum value of 100,000, did we mean that on an annual basis? And the answer is yes. The value cannot exceed that. So if the value went up $110,000, then the excess, the 10,000, is considered a countable resource under both the SSI rules as well as the Medicaid rules. So it's so important that not only the trustees who administer the ABLE account watches over it, but anybody that's assisting the adult with the special needs trust, the ABLE account needs to watch over carefully as well. So all great questions. I want everybody who joined me today to stay motivated. Think about the things that we talked about. Make your questions, make your notes on a piece of paper, schedule an appointment, and keep moving in that forward direction to create a comprehensive plan for your children. And again, I want to thank you for joining me and for supporting me. Have a wonderful afternoon. And please join me, if not this Friday. Look for future invitations for the month of June.
Thank you,